Hi, everyone. This is Stephanie Scarborough, and welcome to our monthly check-in on the Visa Bulletins. The Visa Bulletin is issued by the Department of State, and it summarizes the availability of immigrant visa numbers, and this is the March 2019 Visa Bulletin update. So it's timely. I've waited a few days to post this video, just mainly because we get a regular monthly check-in with the Department of State, where they provide projections for coming months and explain some of the items in the Visa Bulletin after they've been posted. And that was particularly important now because we'll be covering employment-based preference categories in this video. And when the March bulletin was posted, the EB5 EB5 was unavailable, as you can see here, and religious workers were unavailable. And the reason they were unavailable is the authorization for these programs was under the Consolidated Appropriations Act of 2019. And that Consolidated Appropriations Act of 2019, which some of you may know, caused a government shutdown. When President Trump signed that, it reauthorized the EB4 religious workers in the EB5, I5, and R5 categories that you see at the bottom of the employment-based final action dates. So when this was published, the Visa Bulletin, religious workers were unavailable, and now they're available. So if you need information related to religious workers or EB5, then that's included in Section 8 below, and that relates to EB5, the continuing resolution signed on January 25th, extending this immigrant investor pilot program until February 15th. I5 and R5 visas may be issued until close of business on February 15th and may be issued for the full validity period. And then that stopped. The final action dates for I5 and R5 categories were listed as unavailable, chiefly because of that Consolidated Appropriations Act. So now that that's been reauthorized, both programs will see movement likely in the religious worker category, as well as the fifth preference category for the EB5. So just a note, that's one of the things I was waiting for. The other thing I was waiting for as we cover employment-based preference categories is just I like to get a sense for what Department of State is thinking for coming months. So let's take a look at the final action dates for employment-based preference categories. And I should note, one of how you use this chart is you have to have your priority date and your preference category. So your priority date is found on your I-797, your receipt notice usually for your I-140, your immigrant petition in the case of employment-based preference categories, or on your actual notice from your Department of Labor PERM filing. EB2 and EB3 preference categories and would have a PERM filing, and their priority date would be listed there. And also on your I-140 receipt notice, your priority date would be listed. For EB1 categories that do not require a permanent labor certification, you would find the priority date on your I-140 receipt notice or approval notice if it's been approved. So you compare your priority date. Your priority date, these are cutoff dates the Department of State has listed for each preference category. And your priority date has to precede these dates in order for you to be able to get a green card or to file, if you're in the United States, an I-485 adjustment of status. The categories are found right here on the Visa Bulletin, travel.state.gov. You can look at the Visa Bulletin. The link will be included in the video. Employment-based preference categories are listed here. Priority workers include EB1A, B, and C, outstanding professionals and researchers, extraordinary ability, outstanding professors and researchers, and managers, executives, who are usually the beneficiaries of intercompany transfer for EB1C. We have a lot of clients who are in the EB1C category who are backlogged, especially India-based clients. So we will address that here on the video. So let's take a look at what we got. So the categories are listed here. If you note, one point of note is that EB1 is still not current, meaning the C indicates current, meaning anybody with any priority date can file their is eligible to get their green card, meaning it's current, the current date. So today would be February 28th. So they'd be eligible to apply for their green card or obtain their green card if it's already in process. If it's a C, current. Traditionally, we saw EB1 as pretty much current across the board for many, many, many years, except for brief periods where it was backlogged. And now we see EB1 is backlogged again, and still backlogged and moving rather slowly. So one of the comparisons you can make is if you compare previous Visa Bulletins with the current Visa Bulletin, and that's done very easily right here on the Visa Bulletin website. February 2019 Visa Bulletin. February 2019 Visa Bulletin final cutoff date for employment-based category for all chargeability areas was December 2017. For India was February 2017. You go back to the March Bulletin and you can compare it thusly, just by comparing the dates directly with the final action dates. So now we've moved up from December 2017 to January 2018 for all chargeability, and we've moved up slightly to February 22nd, 2017 for India. So slow movement on EB1. In fact, the Department of State is reporting that there will continue to be very slow movement on EB1. And they should note, the State Department notes that, as predicted, just very modest movement is going on with EB1 category in the final action date. So all chargeability areas worldwide would be December 1st, 2017, just moving, as we said, to January 2018. And then same thing with India and China. They're creeping very slowly 3 weeks, February 2018 to February 22nd, so February 8th to February 22nd. So we should note that you will see EB1 worldwide in China and India moving very, very slowly in the next few months. So don't expect gigantic leaps to happen in EB1. If you are sitting, for instance, with a priority date that is in 2019 or in end of December 2018, I think a few months ago I would have said you can expect probably to get your green card in the next 6 or 8 months. But I expect that to move very, very slowly over the coming months because of demand. So we'll see those creep up just a few weeks at a time or maybe a month at a time for worldwide because the level of demand has been very high. And I should note that the Department of State noted that after the February bulletin was published, they had nearly a 50% increase in demand. And that's why we saw a very slow movement on the March bulletin, because the State Department actually just gauges month to month. They really, really do a very intensive job of tracking the demand, the number of applications filed, the number of individuals filing adjustments of status who are able to file adjustments of status, and the number of individuals who are seeking their immigrant visa abroad if they are seeking an immigrant visa at a consulate. So they track those. And after the Visa Bulletin was published, I think it was February 12th or January 12th for the February Bulletin, when that bulletin came out, the increase was so high that they had to move things really slowly. And they actually the State Department actually expects to continue to move them slowly. The other striking thing you can look at is an employment-based second preference category and third preference category is how India has flipped EB2. So EB2 and EB3 have flipped such that, we have the later date here means that more people can fit in before it, right? The cutoff. So if you're 21 May of 2009, you can now file for your green card, your I-485, or obtain your visa abroad at a U.S. consulate. It used to be, and there was a big push a couple of years ago for EB2 upgrades because EB2 was much faster than EB3. Now we have it flipped, as you can see. Very flipped slightly now. And I think the State Department originally, when they spoke at the end of last fiscal year in September of 2018, they were projecting that it would take until end of this fiscal year for these dates to flip. As you can see, just because of demand in the second preference category being higher, we see that EB2, EB3 now exceeds EB2, meaning that those people who upgraded and are now in the EB2 category, who were hoping to advance further and faster than EB3, now will face longer retrogression than the EB3 candidates. So that's a very interesting change. And we see Guatemala and worldwide EB2 is current, Mexico and Vietnam. So everything else has moved very, very slowly. China and India have moved extremely slowly and do not expect to increase and move very quickly through May. In fact, I should mention that in February or in January, the Department of State gave projections through May of 2019. And in those projections, they stated that worldwide would stay current for the foreseeable future, at least for EB2 and EB3. And China and India would move like up to 3 weeks, or in India could even move in EB3 up to 3 months through May of 2019. Well, this month, in February 2019, the Department of State is reporting that they've actually met all of their projections through May of 2019. So what that means is we can expect things to continue to be slow in EB2 and EB3. So just keep an eye out on those numbers. Don't expect huge gains in at least through May. You'll see them move very, very slowly, sometimes advancing only like 1 week, for instance. So given these advancements, and unless there are changes in demand trends, then you can expect this very, very slow movement for EB2 and EB3 to continue, and you can expect EB3 to be to move along faster. Even in China, you can move it. It'll move faster than EB2. So the final action dates, for instance, for EB2 India, only advanced by 3 days in March. And the final action date for EB2 India was already ahead, and and EB3 is going to remain ahead of EB2. So we knew, and it's sooner than we expected EB3 to exceed EB2, but that's what happens. So that begs the question of, if you're in an EB2 category and you're from India, and you see this trend happening where EB3 is exceeding EB2, do you downgrade your petition and try to get into an EB3 category? And these are trends, and I have to say we don't know how long these trends are going to remain this way. We don't know how far EB3 is going to exceed EB2. It just all depends on demand. If a bunch of people start filing for downgrades and do EB3 in place of EB2, then EB3 will slow down as well. So it really depends on demand and how many people are going to file and start changing. I tend to want to watch these trends a little while. You can react and you can make a change, but that change in the end might hurt you because you've downgraded to an EB3, and now there's too much demand in EB3, and that's going to backlog. So obviously, if you look at these dates and you're filing a permanent residency application today, you file a PERM, which is the labor certification for EB2 or EB3. Your priority date is going to be, let's say you're filing the PERM on March 1st, 2019. Just looking at the numbers, you can reasonably assume that you're going to wait 10 years. And that's just the numbers that you're looking at here. So you could say, I know I'm going to wait 10 years, roughly, right? So it's a projection from your priority date. In reality, the wait time is substantially longer than 10 years, but just kind of gauging it, you have to start thinking about career decisions and strategies and How do you maintain? Can you maintain it? Let's say you're in the United States on an H-1B. Can you maintain your H-1B for that decade that it's going to take to get your green card, or more than a decade to get your green card? And these are real like personal strategy decisions you have to make. So EB2 and EB3, there you have it on the employment-based category. I wanted to address EB1, India in particular. China would be in the same situation, but EB1 is backlogged to February 22nd, 2017. As we noted, it's moving along very, very slowly. So some of you might think, well, my priority date is January 2017. I can get my green card now. And that would be terrific if that really happened that way. But what we're faced with is a situation where not only are you waiting because of the backlog on EB1, 2, and 3, but you're also waiting because of the I-485 backlog. And I'll give you an example here on I-485 backlogs. So in Atlanta, Georgia, for instance, so right now every employment-based category is scheduled for an interview. I should say not every case 100% is scheduled for an interview, but employment-based category, employment-based petitions are supposed to have an interview. So if you're needing an interview, you have to go to a field office if you're in the United States for an I-485. So you filed, let's say when you filed your EB1C manager executive from India or China, you are living in Jacksonville, Florida, or Atlanta, Georgia, where our offices are. You may be waiting up to 23 months for that processing. So if your priority date is current in 2019, and you file your I-485, your I-140, and your I-485 concurrently, let's say, or even your I-485, then you're going to wait, possibly 2 more years for just an interview. And that's from the time that USCIS gets your application. Now, I should say there has been some movement on that. Last month, whenever I checked this, in our last month's webinar, those dates were up to 38 months. So we're seeing some movement on here. And how you check it is you just go into the processing times. So if your 485 is being processed in Buffalo, New York, it might take only up to 22 months to process. So if your priority date becomes current today because your priority date precedes one of these cutoff dates, wherever you're chargeable to, then you just expect that you're going to wait a couple of more years. Now, why is this important? So I should note, just a note on chargeability. Chargeability is where you were born. So if you were born in Europe, in any of the European countries, for instance, and you're a citizen and you were born in Germany, let's say, then you're chargeable to all chargeability areas worldwide. So if you're born in China or India or Mexico or the Philippines, Vietnam, then you're chargeable to those countries that you were born in. The other note is just becoming naturalized in a new country won't help you change chargeability. Like one of the ways, if you're looking at this, you may say, well, I'm chargeable to India and I'm greatly backlogged. If I just get citizenship somewhere else, I want to be chargeable to the new country. That doesn't work. Chargeability goes based on your nationality and where you're from. However, if you're married to somebody who has a European chargeability and you're from India, then you may be able to use what they call cross chargeability and use your spouse's chargeability on the green card. And that's always something to look into and seek immigration counsel to see if you qualify for that. So back to these dates, and we were talking about EB1 category. And I'll use the EB1C category as an example, intercompany transfer, because intercompany transfer relates, generally what you'll see is somebody coming into the United States on an L1A as a manager executive. They're sitting on an L1A, and they get a maximum validity of 7 years on an L1A. You cannot extend beyond that 7 years on the L1A unless you go out of the country, stay out of the country for a year, and then come back in, or unless you're intermittent L1. and that's a different category that we're not going to discuss on this video. But most cases you're going to max out at 7 years on the L1A. So let's say you've been trying to convince your employer to file your green card, and you're expiring in this is a real case I have. We're expiring in January of 2020. Your employer dragged their feet, finally decides to do their green card. We're going to file your green card in March of 2019, and your priority date is going to be, let's say, March 1st, 2019. You only have a year to stay in the United States, less than a year now, because you're expiring in January 2020. So I can file right now an I-140 immigrant petition for you, and you're going to get a priority date of March 1st, 2019. I would hope, if you're all chargeability areas, you're going to watch these numbers very closely to see if they move forward. We already know that EB1 is not going to move forward extensively between now and May of 2019. So I think the most you can hope for all chargeability areas, maybe, let's see what the Department of State said, maybe a 1 month movement, 1 to 3 months movement between now and May. So if we get just, even moderate movement between now and May of 2019, then that's going to advance January, February, March, April of 2018. So what's going to happen is you're going to need a 1 month advancement all year long, or even a further advancement, in order for this cutoff date to be in a place where you can file your I-485 adjustment of status and before your 7-year maximum validity runs out in January of 2020. So if this moves 1 to 3 months over the next year, and let's say we get to December of 2019, and this priority date, this cutoff date is let's say it's April of 2019. Perfect. You can file your I-485 adjustment of status, and you can remain in the United States, even though your L1A is expiring, because now you're within a period of authorized stay. The problem is you're not going to have employment authorization once your L1 expires, because right now an employment authorization document for an adjustment of status is taking about 5 months to process, 4 to 5 months to process. So if you're eligible to file and you file your I-485 adjustment of status in December of 2019, because your cutoff date is current, then what happens? You wait 4 to 5 months in the United States without employment, because you cannot work without authorization. So once your L1 expires, you can remain in the United States, but you can't work. So think about those strategies as you look at your timeline. How much time, if you're on an L1A, how much time do you have remaining in the United States? So chances are, if you are in almost any of these categories, it's going to be very, very tight for whether or not you'll be able to file your adjustment of status or remain in the United States employed after January 2020, let's say, if that's your 7-year maximum. So what I do is take your L1A expiration date, look at that expiration date, and figure out how close are you going to cut this, or are you going to have to leave the United States, because it helps to plan now. If you have children who are in school, for instance, that's January 2020 is in the middle of their school year. What are you going to do with them? Are they going to stay? Were they born here? Do they have status? Are you going to go offshore and then come back onshore? Think about things like that. And for those of you in India and China, we expect those dates to creep along. We've seen they've moved forward 3 weeks this month between the February and the March bulletins. India and China are really hurting in terms of, if you filed an I-140 today in 2019, and India and China, we know the State Department's telling us that it's going to move forward very, very slowly through May of 2019, and that demand has not lessened. So let's say it moves, less than a month over the next 3 months between now and May, the May bulletin. You're just not going to make it. If you're filing March 1st, 2019 as a priority date, you need this to move very rapidly forward, India, by 2 years, more than 2 years. And the chances of that happening, if your L1A is expiring next January, are very, very slim. So you start planning now. Ideally, we're going to a situation. I used to tell people who are on an H-1B, for instance, to start talking to their employer at year 3 when you're filing your first extension of stay on your H-1B. If you got 3 years on your initial, start talking to your employer then about the perm, because you get your permanent labor certification. The process takes so long. You can get your I-140 approved. On an H-1B, it can extend beyond the 6 years. We'll cover that in a second. But on an L-1A, you just don't have that opportunity. So we need to start thinking about L-1A the same way. By year 3 or 4 of your L-1A, when you're, what you usually do on an L-1A is typically, if it's not a new office, you'll get a 3-year initial validity period, and then you'll extend for 2-year increments. When you're working on that first extension, that's when your employer needs to be thinking about whether or not you need to apply for the green card. And again, we're just talking now about the priority dates, and the priority date's moving along. But what happens then is, you're stuck in this processing period. And I've had people processing now for a couple of years on an I-485 because of this this requirement that came in 2017 to have employment-based interviews. Employment-based interviews, frankly, they're there for a reason, and that's to verify that the position is still available to you, and that you're able to fill that position, that you've maintained your current status, and that you are still admissible to the United States, and haven't had any crimes and everything. But for the most part, that information can be verified through a request for evidence or an update provided to the service without scheduling an interview. The interviews, frankly, to me, are just quite useless. Everybody's being scheduled for an interview. It's backlogging the field offices. The field office personnel don't understand the I-140. They don't understand enough. They understand the 485 because they're adjudicating family-based 485s, but they don't understand the I-140. And frankly, the inquiry isn't that deep into the position itself to know whether you're filling that position. You go in and they take your picture and your fingerprints, and they process you and ask you a few questions about admissibility, and go through the I-485 form, and off you go. It's a pretty quick process. As far as real verification, USCIS would have to do some training in order to really verify whether the position is still available, other than the, requiring an I-485 Supplement J, which verifies your availability of your position, or a letter from the employer. So those I-485 interviews are just another way of slowing down the green card process, and really bogging up the system and making legal immigration more difficult on people. So once again, I digress into policy, but final action dates, we're back to EB2 and EB3. If you're from any country other than China, India, and the Philippines, EB2 and EB3 are current. If you are from China, you're in a little better position than India because you're at 2015 and 2016. Your wait time isn't as long for your priority date to become current. India, EB3, longest wait. Why is it the longest wait? Because it's the highest demand. So that's why you see 2009 backlogged. So these dates, easy to determine whether you qualify. It's 2009. Is your priority date, does your priority date precede these dates in this category? If your priority date precedes these dates, then you're eligible to file your I-485 or obtain your immigrant visa abroad. If not, then you don't. You're not eligible yet. So you'll have to wait until your priority date is current. So watch those dates closely. And this is for adjustment of status. And I should mention something about adjustment of status versus immigrant visa processing. If your priority date is nearing the time of being current, or you are already current, which is happening a lot now, is your priority date is already current, but because of the backlog in I-485 interviews, you're waiting another year or two for an interview. In some cases, you may look at, we're going to talk about this chart in a second, but in some cases, you may look at whether you would be better off immigrant visa processing. So if I'm making a decision today on an I-140, is filed and approved, let's say, and I'm trying to decide whether to immigrant visa process or adjust status. Today, if my priority date is being current, I would probably try to definitely look toward immigrant visa processing. Why? Because the process is just quicker depending on which consulate you're going through, and that's just checking the State Department website to see how long it's going to take to do an interview. The National Visa Center will take 11 to 15 weeks to process your case, maybe a little longer. They're also going to take time to schedule your appointment. But let's say that takes 6 months to process National Visa Center and then get an appointment at your consulate. You're still well within the timeline of the alternative, which is the adjustment of status in the United States, this 22 months, up to 22 months. Now this, again, I note that these dates are improving. This was 36 months just when I went over my February bulletin in January when the February bulletin came out. So we see that end time improving, but still the start time is 10 months. So that was Buffalo, an I-485 in, let's pick another busy area like San Francisco, right? If you're doing an I-485 in San Francisco, you can wait up to 20 months. That's also an improvement, but look at the lower range, 17.5 months. So you're going to wait almost a year and a half versus potentially only waiting, let's say 6 to 8 months, maybe even a tiny bit more. Even if you have to wait a year for your immigrant visa processing at a U.S. consulate, you're still making out better time than waiting for an appointment. So that's something to talk about with your counsel and really weigh it with your family about whether immigrant visa processing is better, if your priority date becomes current, than adjustment of status, because adjustment of status is going to delay. Although adjustment of status has benefits, and that is if you file an adjustment of status, a green card application while you're in the United States, then you can also get a travel document and work permit, and you can continue working in the U.S. So not everybody will be able to immigrant visa process, but that's why you talk to your counsel about immigrant visa processing versus adjustment of status, because I have people who are changing to immigrant visa processing just because the adjustment of status is taking, projected to take 2 years. So they'll do an immigrant visa process because they have plenty of time left on their H-1B or their L-1 or whatever their underlying non-immigrant status is, so that they can immigrant visa process. They'll probably have their green card, a minimum of 6 to 12 months before their cohorts who are doing adjustment of status. Again, but that's a personal issue, and there are a lot of considerations to think about in terms of whether you immigrant visa process, whether it's easy for you to travel abroad, whether you've maintained your status in the United States, whether your kids are in school here, all of those things. So just briefly, I want to talk about green card backlogs. We talked about them in the context of the Visa Bulletin, just being backlogged here for 10 years. If I file an application today, a permanent labor certification today, March 1st, 2019, then I'm probably going to wait a little over 10 years for my priority date to become current. But the other consideration is just, look at the I-485 processing times. So these are processing times at the service center. If my priority date is in 2009, there are 10,000 cases processing right now at the service center. So with 10,000 cases processing right now, there's going to be a substantially long wait for my case to be processed. So if you look at how quickly they're moving through, green card priority date numbers are moving just terribly slowly. So you have the I-485 that's delayed. You also have processing times, at the USCIS. So it could take years to clear. For instance, you have 10,000. It could take 3 to 4 years to close out 2009 India EB2 backlog. So the EB2 backlog, you have 10,000 cases here processing that USCIS has to process for the 2009 EB2. Those 10,000 cases have to be processed before they get to your case. So it could take years and years more. So there's processing times, and there are predictions. We'll see that India EB2 queue is barely moving. I don't think we're going to see that. And this is processing of the I-485. These are people whose priority date is current, or they had a priority date of 2009, and USCIS is processing the applications. So the USCIS has a long way to go to clear these 10,000 applications. A couple of here for 2010, you have 4,600 in EB2. EB3, not too many, because EB3 for 2009 wouldn't be current, so they seem to be keeping up with EB3 third preference category. But EB2, there is a backlog, and it could take years to clear this. So when you're considering, that is, again, I-485 processing. That's if you're in the United States and you want to process, you're waiting for this time frame, the date of the appointments, and before you can have an appointment, you have to go through central processing at the service center. So the National Benefits Center will review your application and send it on to the field office. So it looks like they have about 10,000 cases from prior to 2009 right now. So that's where the backlog is. Same thing for India, EB1, 2016, they still have 1,900 applications pending here. So that's just at the service center. That doesn't include what's already been forwarded for interview at the field office, and the field offices are backlogged, as we saw, up to 20 months in most cases. So I guess the point of the Visa Bulletin now is everything is moving very, very slowly. In the April Bulletin, we should see an advancement of religious workers and EB5. Given the appropriations bill has been passed, so we'll see those move on. But really, for EB1 all across the board, and for India and China, we're seeing very, very slow movement on EB2 and 3. So the backlog continues. And what is the answer on the backlog? I frankly don't know what the answer is on the backlog. Congress would have to act and move these along. There is some talk about taking and removing employment-based categories from the Visa Bulletin. I should caution people who get to not get overly excited about that, because India still is the highest demand, meaning on a percentage basis, if they were issuing immigrant visas based on demand, then you can expect for India to still be backlogged. Maybe not as much if they take EB3 or take employment-based preference out of the Visa Bulletin categories, but you're still going to be backlogged, you're still going to be waiting. It's just a fact of life, unfortunately, for India, given the demand. Same thing with China. You're just going to have that because these numbers are set based on the demand coming into the United States, and statutorily we can only allow so many people in the United States at a time. All those details are found in the top of the Visa Bulletin here, 226,000. So just keep that in mind as to how these are allocated, and it's just a fact of life. Unfortunately, this needs to be fixed somehow. There needs to be some kind of relief for people who are waiting in this backlog. EB1 backlog, I'm seeing a lot of L1As, for instance, who are executives in companies or managers, senior managers in companies, who are having to leave the United States because they didn't expect the EB1 category to be backlogged for so long. So, that's an issue. The other issue with these categories is your children are aging out during this time. So if you have a child and you're in EB1 and your child is a teenager, then you have to be very mindful that your child will age out at the age of 21, meaning that your 485 has to be filed by the time before they turn 21 in order for them to be considered as part of your green card application. And same thing, EB2 and EB3 India, that's even a larger concern, because your child essentially has to be very small when you apply in order for you to have hopes of, say if they're not born in the United States. If they're not born in the United States, you come here when your child is 7, you need to get that application filed as soon as you can in order for your child to not age out. Frankly, in order for your child to not age out, you literally have to file when your child is young. That is, if your child is not born in the United States. So, once your child turns 21, they're an adult and under the eyes of the immigration laws, and they're not part of your immigration application. So, so just keep that in mind. Those timelines are very important, and that's where it pays to, talk to an attorney early. Keep them updated on your family status. Make sure that they know, when your child is approaching age out, and start looking at these dates and really, take them under consideration in your personal strategic planning for your family, because how you plan your H-1B career and your L-1 career, it impacts. You cannot wait any longer until, the last 4 months of your L-1A and have L-1A current and file an L-1A EB-1C application and expect to get your green card quickly. If so, you'll be lost, and you'll lose your L-1A status because you hit your maximum and you'll have to leave the United States. So very real considerations. Watch these dates closely. Not going to move much between now and May. Any hopes we have will probably be for larger movements, would be the end of the year, and it really depends on demand, the end of the fiscal year and beyond. So keep an eye on these dates. If you're getting close to those dates, but be prepared to make a decision as to adjustment of status or immigrant visa processing, because those are 2 opportunities to shave some time off of processing times once your priority date is current. And then check back with me at some, later. We'll have the April bulletin, which usually comes out around March 12th or 13th. It should come out. This month it was a little delayed from what I recall. I was watching for it. This was published February 8th. I don't think it was posted though until the following week. So just keep that in mind, that they'll publish this bulletin early in the preceding month. So that's the employment-based categories. I should note, you noticed I was on final action dates. Final action dates are the dates that you go to for where you can get when you can get your green card, or when you can file an I-485. Dates for filing are used as a tool for kind of early processing during the at the National Visa Center. So if you're immigrant visa processing, this is how I will close this, because this is an important point. If you're immigrant visa processing, you can submit your documents earlier to the National Visa Center. And what that means is, in terms of, we were talking a lot about shaving time off immigrant visa processing versus adjustment of status. What that means is, if your priority date precedes October 1st, 2017, so if you're September of 2017, you can, or before, then you can start sending your documentation into the National Visa Center. And what that means is you just get a jump on processing times, whereas, you wouldn't be able to do that. You would essentially lose, 6 or 8 months of processing time on adjustment of status, because you can't file your adjustment of status for many months later. So, really take a look at immigrant visa processing and whether that's appropriate in your case. Again, speak to your counsel, because this webinar is not a replacement for your advice of your counsel, but check back with me or ask any questions below, and I'll try to get to them, to the questions. Again, thank you for joining. This is a March 2019 Visa Bulletin update on employment-based numbers by Stephanie Scarborough. Have a great day.